has 3.
Chair, which one would you like me to do?
Well, it's up to you. Item number 2 might as well go with item 4 to item 7. This is AB 144.
Okay. Thank you, Mr. Chair and members of the committee, and thank you for the opportunity to bring this issue forward today. I want to begin by thanking the chair for his interest in joining as a co-author of the bill, and welcome any other members who would like to join during the next set of amendments, as hopefully this bill progresses out of this committee. So thank you, Mr. Chair. I would also like to thank the stakeholders on both sides of this issue for working with my office and committee staff in efforts to improve the contents of this bill. For some, there has been much passion surrounding this debate. The vast majority of the people contacting my office have done so with respect and civility, and for that, I and my staff are very grateful. AB 144 seeks to close a loophole in current law by which an individual is allowed to openly carry an unloaded handgun almost anywhere in California. Specifically, this bill will make it a misdemeanor to carry an exposed and unloaded handgun in a public place, while providing a list of reasonable exemptions for law enforcement, hunters, rural residents, and individuals participating in parades or lawful and permitted demonstrations. As many of you have experienced in your own districts, the absence of a prohibition on open carry has created an increase in problematic instances of guns carried in public, alarming unsuspecting individuals and causing issues for law enforcement. Open carry creates a potentially dangerous situation. In most cases, when a person is openly carrying a firearm, law enforcement is called to the scene with few details other than one or more armed individuals are present at a location. In these tense situations, the slightest wrong move by the gun carrier or law enforcement could be construed as threatening by the responding officer, who may feel compelled to respond in a manner that could be problematic. In this situation, the practice of open carry creates an unsafe environment for all parties involved: the officer, the gun-carrying individual, and for many other individuals nearby as well. Additionally, the increase in open carry calls placed to law enforcement has taxed departments dealing with understaffing and cutbacks due to the current fiscal climate in California, preventing them from doing other necessary duties. We are joined in our efforts by both law enforcement and gun violence prevention groups. The bottom line, members, is that open carrying of weapons is something that belongs on a Hollywood movie set, not on Main Street or Starbucks. You don't need a sidearm in order to buy a cheeseburger. With me today to provide further testimony and answer any technical questions you may have, we have representatives of the Police Chiefs Association, PORAC, and the Brady Campaign to End Gun Violence, and I would respectfully ask for an aye vote.
Thank you very much. And 2 witnesses, 2 minutes.
Mr. Chairman, again, Ken James, Chief of Police of the Emeryville Police Department. I'm also here representing the California Police Chiefs Association. Our members are responsible for over 78%, the public safety of over 78% of California's population, and we strongly support this bill. We see this simply as an officer safety issue. We are called to confront a gun. We cannot make the assumption that that gun is loaded or unloaded, and we must treat it, as was mentioned in the other bill, with caution and tactics that would protect our officers. Having these guns in a public setting just creates a problem for my officers and officers throughout the state. We have to confront that gun. We have to make sure that that gun is being legally carried. And we have no idea of who's carrying that gun when we do. This, pure and simple, is an officer safety issue. And we urge, California Police Chiefs Association, urge your support of the bill.
Thank you very much. Next, please.
Hi, again, Amanda Wilcox on behalf of the California chapters of the Brady Campaign to Prevent Gun Violence. We feel that very strongly that this bill puts the public at great risk. I just want to remind you that individuals who are carrying unloaded guns but with ammunition readily available have not undergone any kind of special clearance or training. There is no assurance that these individuals carrying guns have good judgment, that they are in control of their anger, that they can make good split-second decisions, or that they can even shoot straight. So I think any slight an altercation in a public spot has the potential to become a deadly shootout, and it definitely puts the public at risk. It puts employees at risk, and you've already heard the problems that it presents for law enforcement. And in a time of tight budgets, I think it's a waste of our precious resources for law enforcement to be called to these scenes of man with a gun when they are taken off their other tasks to be. So in the interest of law enforcement, the public, and actually for the gun-carrying individual who is at risk of being shot by law enforcement, this bill would save lives. So we strongly urge your support. Thank you.
Thank you, Mr. Hack.
Mr. Chair, and sorry, a few more questions on this one too. So in California, you have two different ways to protect yourself if you want self-defense. One is concealed carry, one is the open carry. You can't carry openly with rounds put in there. So I guess back to the law enforcement question is, the Ninth Circuit has ruled very strictly that the sheriff and the county chief of police can give without the cause, the permission to give someone the CCW or not. Most counties in California do not give a lot of CCWs out. I'm wondering from the experience, is that do you believe this is going to increase the applications for those who want to have self-defense on their own property, protect themselves and their property? Is the law enforcement going to open it up to CCWs? Because I don't see either way you could do it without. Or is it the purpose here to eliminate basically people carrying guns in California that's constitutionally allowed by to have? So I just kind of want the response.
I'll respond sort of in global, and then obviously the chief should deal with what the chiefs are going to do. This bill does not change the local control aspect or the local CCW system. There are laws that govern those issues. This bill seeks to close a simple loophole in our current situation that allows a person without a license to openly carry a handgun. Obviously, each county deals with the CCW issue. Each sheriff deals with it in their own way. This does not interfere with that. They have their own reasons locally of who and how they grant those permits to. I'm not seeking to tell the law enforcement how to do their job in their counties. That's their purview.
Maybe we can hear from the chief, and then when Mr. Hack is through, Ms. Yamada, do you have a question?
And there are other witnesses and so forth.
As far as do I speculate that there will be additional CCW applications, I don't think so. I think that individuals that are doing open carry now have applied for CCWs, and some have been granted. Just an anecdotal story from the sheriff of Alameda County, who does the CCW licensing for most of the law enforcement agencies in Alameda County. One of the prime proponents for open carry came in for CCW, and as part of the psychological evaluation was deemed unfit to carry a gun, but yet, in a concealed manner, but yet he was capable of carrying a gun openly with the bullets in his pocket. So, do I see this occurring? More CCWs? No. I don't see any more applications to it, but I also see the fair applicable judgment of the sheriffs and the chiefs in providing for the carry of a concealed weapon. Yes.
Is that satisfactory?
Just, I guess, a little commentary that, I do believe this is one of our very core rights that we have by the U.S. Constitution, and if this thing passes, it really leaves no honorable citizen who has to go through a background check. There's already rules and laws against brandishing or threatening with firearms. No ability to protect themselves one way or the other. You can't get a CCW. Most counties do not issue CCWs in a very limited amount. I'd hate to see what the small percentage do compared to other states. And then the fact that you can't carry down properly, bolstered, safely on the way if you want to protect yourself. Even in certain areas, your own properties, stuff like that. There is some provisions on your own ranch, but it seems like basically the purpose here is to eliminate any kind of gun usage in California besides law enforcement.
All right, thank you. Any other witnesses in support? Name and affiliation, please.
Mr. Chairman, members, Randy Perry with Air Reed Associates on behalf of CORAC who strongly support the bill.
Ben Van Houten on behalf of the Legal Community Against Violence and support the bill.
Jim Lindbergh and Friends Committee on Legislation, California, in support.
That's it? All right. Any witnesses in opposition? DB come to the table. 2 witnesses, 2 minutes. Did you want to move the bill? I'm sorry.
Yes, actually, if I may have that privilege, I'd be delighted to. I don't think so.
Well, give it a try.
Thank you.
I'll second.
Good.
We respect
Mr. Chairman, members of the committee, and Warriors of the National Rifle Association. I want to thank Assemblyman Portantino. We've had nice discussions with him and his staff. He's been very cordial, and we've had a very professional conversation. I appreciate that. Although we may disagree on this issue. The reason we're sitting here this morning talking about this bill is a very simple reason. In many jurisdictions in the state of California, there is blatant discrimination on the issuance of concealed carry permits. In one county, we had a police officer, we had a person who is a Class 3 gunsmith who repairs machine guns for law enforcement, has a federal license to repair machine guns and silencers. This person was denied a concealed carry permit when they transported machine guns to and from a law enforcement agency because the sheriff in that jurisdiction had decided that they were not going to issue any concealed carry permits for any reason. We have a Los Angeles Police Department who's under a court order to reevaluate their concealed carry process as in violation of the court order. So what you're seeing is you have 2 different situations for a person to be able to protect themselves while they're out in public. They can go lawfully try to get a concealed carry permit, but because the law is so flawed in the state of California, you have blanket discrimination in carrying concealments. So the only other option people have in some jurisdictions is they have to openly carry the firearm openly. Now, if you go to other states like Arizona and some other places, you can carry a firearm in open plain view loaded. One of the things we've talked about in this bill is I've constantly asked proponents of the bill, show me any instances to where there's been a problem where the person carrying the firearm openly has been arrested for any reason. They don't have one. It makes people uncomfortable, but that's the nature of our free society. People are uncomfortable all the time about different things. But what you're going to find is this bill is going to present to you a conundrum, and I'll use that phrase, a conundrum for you. Because if you take away the only other option for people to openly carry to protect themselves, you are going to be helping our court case in San Diego County called the Peruta case, where we sued over the ability to issue concealed carry permits. Thank you.
Thank you very much. Next speaker.
Good morning. My name is Chuck Michelle. I'm an attorney for the National Rifle Association. I also represent a number of other individuals who have challenged concealed weapon issuance policies in a variety of cities and counties, including most recently the county of San Diego. That's the Peruta case. In that case, the district court judge found that our contention was that because of, in light of recent Supreme Court rulings, the Heller case and the McDonald case, police chiefs and sheriffs issuing concealed weapon permits must accept self-defense, the fundamental individual civil right to self-defense, as quote-unquote good cause for issuing a concealed weapon permit. In that case, and because you have a right to keep and to bear arms, there needs to be a way for you to be able to possess a firearm outside the home for self-defense. The only reason that case was, that Peruta case, we did not win in the district court, it's now an appeal, was because the district court judge said that as a practical matter, should the need for self-defense arise, nothing in section 12031J, that's the exception that allows unloaded open carry, restricts the open carry of unloaded firearms and ammunition for instant loading. As a consequence, the court declines to assume that section 12031 places an unlawful burden on the right to carry a firearm for self-defense. In other words, that exception that you're now considering eliminating through this bill is what saved the county from not having to basically go shall issue and have to issue concealed weapon permits when someone cites the civil right to self-defense as a good cause. So as a policy matter, I don't think this is really a necessary law. These people are just demonstrating basically that they believe in the fundamental right to keep and bear arms. I actually represent several cities that have gone through training how to respond to these types of demonstrations. It's not a big deal once they get the law down, most officers weren't aware of it. But as a legal matter, I'm a bit conflicted because basically